Friend William Trackman with the Mountain States Legal Foundation. He joins us. He knows a lot about this particular case. William, thanks for being with us on this Monday. I think I spoke to you Friday, so we're talking about yet another major case that was heard today in front of the Supreme Court about big tech, censorship, disinformation, and this stems from 2020 all the way back then. And so, you know, the Associated Press kind of was framing this. I want to get your thoughts on whether you agree with the framing that the justices seemed broadly skeptical during these nearly 2 hours of arguments today. They say the Supreme Court seemed likely to side with the Biden administration on this. Do you see it that way? Is that what we can kind of read from how the justices were talking about this and the questions they were asking today?
I would describe it as uncharitable, Andrew. So the justices were looking for really clear evidence. Number one, that someone's speech had been restricted. Number two, that the social media company only restricted that speech because the government told them to. So in terms of a temporal limit, there was questions about whether the government telling you something 2 months ago and then the social media company acting 2 months later was close enough in time to really prove that it was the government that was at fault for this. And so I found the justices to be very stingy in terms of what they were actually reviewing in terms of evidence. So I do agree with the idea that they seem skeptical for that reason.
Okay, yeah, that seems to be somewhat of the buzzword this Supreme Court cycle. After every oral argument, it seems that's how the justices' questions were being characterized and described, but I digress. You know, William, walk us back, you know, post-2020, these states that brought these suits, because this has been somewhat kind of lingering in the lower courts. I know there was a ruling at the appellate level as well, but now it's to the big court, the highest court in the land, the Supreme Court here. But how did we get here?
So Missouri and Louisiana sued the federal government on the basis that those social media companies were suppressing individual speech, and that it was the government that was behind the scenes as puppet master telling these companies, you ought to do this, you ought to prevent individuals from questioning the COVID-19 vaccine or questioning whether Hunter Biden's laptop is real or not. And so the social media companies were going ahead and listening to the government and doing this censorship. Now the question, of course, is whether the government was merely urging them to do that or whether it was really pulling the strings and making threats. That seems to be the line that everyone's drawing here.
Yeah, you know, William, though, from what I remember, and correct me if I'm wrong, but after the appellate review of this, wasn't the Biden administration, you know, folks there, X, Y, and Z, prevented from communicating with folks at some of these social media companies over this very question? I mean, that was a ruling, wasn't it?
Absolutely. So the district court, the trial court, ruled in favor of the states and the respondents here, saying, yes, the social media companies are enjoined from doing this sort of behavior with the federal government. Yeah. And then the appellate court, the Fifth Circuit, affirmed that. Yeah. But it was the Supreme Court that stayed or put on hold that ruling. So where we are is back to square one. And the question is whether this case is going to come out in favor of the states or the federal government. Based on the oral argument, it sounds like the pause on that injunction is going to continue.
So, Willie, what's, you know, the Biden DOJ's rationale and arguments today there in court? What was their side? I mean, why do they want to bring this in the first place? Do they want this, you know, practice to continue? Do they just want open lines of communication between social media companies and particular White Houses here? What are they arguing?
Well, what they say they want is certainty. They don't want to worry that if they reach out to Facebook and say, hey, you've got misinformation, that all of a sudden is going to be unconstitutional. Or suppose Karine Jean-Pierre yells at the New York Times. Is that going to be unconstitutional now because it's exercising coercion over media? And so that argument seemed to resonate even with the conservative justices like Brett Kavanaugh, who said, well, I worked in the Bush administration. We yelled at the media all the time that they were doing a bad job. Is that unconstitutional now? And so that's what they say they want. In reality, I think the Biden administration wants what almost every presidential administration wants, which is influence and power. They'd rather have their narrative out there than not out there, and they'd rather have their narrative be alone, whether it's COVID-19 or the next government program.
You know, it's so interesting. You have these really major free speech, social media cases in front of the Supreme Court. Just a month ago, we were talking about, what is a social media giant like Twitter or Facebook or Instagram's kind of, onus or imperative to take down content that is deemed harmful from their perspective. But this is, the government, or at least the argument is the government is compelling the social media giant to take it down rather than, Twitter or Facebook's kind of internal safeguards at play. The initiative is from a White House, correct? Or a federal agency or an administration official?
From the highest rungs of the White House. The officials of the White House are individually talking to these social media companies. You're absolutely right. And the Louisiana Solicitor General made a good point of this, saying last month the social media companies were here in front of you saying how important it is that they have autonomy, how important it is that they moderate their own content. And then all of a sudden the government is here saying we need to exert influence and persuasion over these social media companies. Not both can be true.
Yeah. Let's talk about that exertion of influence, so to speak. So, kind of the Biden DOJ's line essentially was that, no coercion what was taking place. It's not like Biden administration folks were going to say punish Twitter or Facebook, say if they didn't take down some of this content that some of these Biden administration folks deemed harmful or deemed disinformation, right? It was merely a suggestion or guidance. And so that is, I think, what is at play here. Can the government compel speech or non-speech? And so that is kind of the crux of the argument, was it not today, from that side?
Well, the justices were concerned about what coercion means. So when you have emails saying, if you don't listen to us, we're really going to have to think about our position on Section 230 of the Communications Act. Or if you don't listen to us, we're really going to have to think hard about whether you might be anti-competitive and deserve an antitrust suit. And so there were concerns that the government doesn't always act in terms of clear punishments. They don't say, because you didn't do this, we're going to raise your taxes or investigate you or do something specific like put one of you in jail. But they often act through winks and nods and through influence and through phone calls. And so here you have a level of coercion that isn't always provable. And that's another way I found the justices to be very stingy today in terms of demanding some sort of evidence of true arm twisting as opposed to sort of vague threats, which is how the government often works. I was in the middle of the government in the Trump administration. Obviously, the government doesn't always put everything in writing and say, if you don't do this, we will do this.
Right. William, I'm kind of curious because some of these posts about, skepticism on the COVID-19 pandemic and the COVID-19 vaccine and what have you, could the Biden administration and the Department of Justice argue that in certain emergency situations, a government entity has the, right or the wherewithal to, compel a social media giant on an emergency application to take down some of these posts that are deemed somewhat harmful, so to speak? Or is that a slippery slope?
So one justice, Justice Jackson, President Biden's sole appointee to the court right now, went there. She was the only one that said, well, maybe it doesn't even really matter whether this is coercive because in the context of a once-in-a-lifetime pandemic, maybe the government has every right to tell social media companies that they ought to take down misinformation about vaccines and and social distancing. And so maybe there was a compelling interest here that the government should have had the right to tell these social media companies to take them down, even if they really were twisting their arms.
Okay.
So even the Biden administration didn't take the bait on that, but Justice Jackson seemed to want to go there.
But that is a slippery slope because, presidential administrations can deem now, I think we've seen post-COVID, anything an emergency, and that emergency can be prolonged indefinitely, so to speak. And any speech that gets caught up in that emergency could fall under that umbrella, could it not?
Well, you could imagine President Trump saying, we have a crisis at the border. It's a compelling interest to make sure that nobody criticizes the fact that we have a crisis at the border because we need to mobilize our entire nation there. And yeah, it is a slippery slope. If this is an emergency, what next? What about the emergency 5 years from now where the government says we had no choice? We had to coerce every social media company and every print media in order to support our message coming from the White House. And certainly that's not the type of country that we expect that we live in.
Yeah, and William, just lastly, too, I always kind of ask you, what does your gut tell you about these cases? But we have the word censorship in our lower graphic that the viewers see right there. Is that too strong of a term when talking about this case, or is it applicable?
I would say it's applicable. If you
Okay.
saw some of the emails in the record, which are before the Supreme Court, you've got government officials cursing out social media individuals saying, why haven't you done this? I'm expecting you to take this content down and you haven't done it. So to me, that really does seem like censorship. Now, maybe granted, there was no consequence if they deleted that email or said, no, thank you. But in the scheme of things, when the White House is telling you to do something, to take someone's speech down, a private citizen's speech, that does seem like censorship.
All right, William Trackman, we'll have to leave it at that. Thanks so much for joining us to help us make sense of kind of a pretty complicated case, and we'll talk soon. Thanks.
Thanks, Andrew.